Mercy for that short introduction. As you've heard, I'm the chair lady of the Hijabi gang, as Mercy likes to call me. I'm joined here by an eminent panelist. The first one with us is joining us online, Dr. Kariuki Mugwa. I remember one of the lecturers, my technology lecturer, telling me, if you Google yourself or someone Googles, let's say Leila, and you don't find anything, clearly no one knows you. I can assure you, if you Google me, you will not find me. But if you Google Dr. Kariuki Mugwa, your phones might crash. So please don't try to do that. Dr. Kariuki Mugwa is a distinguished law scholar, environment consultant, and accomplished mediator, and a chartered arbitrator. He's a holder of a PhD in law from the University of Nairobi with widespread training. He's recognized regionally, nationally, regionally, internationally, globally, partners rating him as one of the best dispute resolvers in the country and also in Africa. He's been described as a highly respected arbitrator and mediator. He has on several occasions been appointed by the Chartered Institute of Arbitrators, Kenya, and other institutions as a sole arbitrator in arbitrations involving commercial dispute. Karibu, Dr. Mugwa. The second person on our panel is Kamau Karori, who is the partner in charge of the dispute resolution practice at IKM. He's been involved in the resolution of many groundbreaking and high-profile commercial disputes in the High Court, Court of Appeal, and Supreme Court in Kenya. He has received accolades both from clients, peers, and leading international directories, including Chambers Global. He was appointed as a co-counsel to defend the Kenya government in a multi-billion-dollar investment arbitration claim, which was determined in favor of Kenya in a momentous award delivered in October 2018. I'm sure everyone knows about that award. In recognition of his status and distinguished service of the nation, Mr. Karori was recently granted the award of Moran of the Order of the Burning Spear. The third person is Deborah Ajwang Ogada. She is the country head legal and company secretary, UBA, Kenya. Her career in banking spans over 13 years. She has served as a legal and company secretary expert in a number of top-tier banks in Kenya. Before venturing into the corporate world, she worked in private legal firms. Our final panelist is Mr. Kenneth Militi, who is well, versed with financial dispute resolution. He's an arbitrator and a chartered banker offering consulting and advisory services to organizations and business involved in imports and exports. Kenneth's career in banking spans over 15 years. He's a member of the Chartered Institute of Arbitration and is an independent arbitrator in financial and commercial disputes. To start us off the discussion, Deborah, from the banking sector, or being involved in it in the past, arbitration has not readily been picked in the financial sector like other sectors, like energy and shipping. There has been a lot of preference for litigation of arbitration. Could you tell us about this case?
Thank you, Leila. I think from the financial sector, historically, the biggest arbitration, more and more we've come to understand what it was, but previously it was something which more the arbitrators and the practitioners understood, but the financial sector, remember the financial sector, we deal with money and time is money. So we really believed that, the only way that we can resolve these issues is to go to court, but nobody really took the time to explain these. Now, coming back closer, and also secondly, we have, if I speak about Kenya, we have a very litigious, and because people don't know any better, but also secondly, because of the way that the court system works, it works for the person who is in court who does not want, for instance, their loan to be recovered. So it works for them. staying in court for very long works for them. So that's why I think we have embraced it. But that has changed, as you know, changed because more and more we found that contrary to what we've in court and a lot of court. So because money is in fact for us, we have changed our perspective and we're now embracing arbitration.
Thank you, Deborah. Dr. Kariuki, are you with us?
Yes, I'm with you. Good afternoon, everyone. I'm with you. I think it is not a question of choice. We were living in a different world, a world which was not connected. But now there is globalization. Let me explain. If you look at what banks do and what they used to do before, it's very, very different. What do they do today? I've heard of what Militi does, import and export. So international trade is part of it. They have all manner of financial contracts between banks and institutions, banks and government. They fund individuals here and abroad. And if you look at the banks and the way they operate, you'll find a bank in Kenya has a correspondent bank in New York. What does that mean? It's dealing with the two kinds of currencies. So there must be agreements between those two banks, the one in Kenya and the one in London or New York, relating to currencies. So already you can see what there is. And then in this very globalized world, people trade in stocks, funds, mutual funds, precious metals. You are going to tell a bank, I have precious metals, I have diamonds in this place. Give me this assurance. And importers and exporters would go for letters of credit. So you can begin to see how the world is changing. And the banks have had to change to deal with changing circumstances, the changing customers, different places, different timelines, different legal systems. And then you could see clearly that you cannot deal with the legal systems using the national courts. So the international system that envisaged arbitration came in because arbitration cuts across legal jurisdictions. So what I'm saying is that they were forced to get into the modern world and operate the way the modern world operates. Thank you.
Thank you, Dr. Kariuki. While you're still with us, are there any potential limitations to the use of arbitration in the financial sector?
Very, very many, because sometimes you would like to have something like summary judgment. And very few arbitral institutions have that. Our own law in Kenya, for example, does not have a summary judgment in arbitration. If a party doesn't turn up, you still have to go on. So that's a downside. And then relating to different jurisdictions, you might find that certain matters are not arbitrable. So two parties are warring and one of them is alleging fraud or misrepresentation. Those are criminal elements. You might find those are not arbitrable. And then arbitrators are human beings. You may find that the bank might not trust them, just like it will not trust courts. So arbitration is not really the panacea to everything. It's also very expensive. Karori will tell you that. So there are downsides. It can also take years. It's not really expeditious. It's supposed to be, but it's not really.
Thank you. My next question will go to Dr. Mr. Karori. Are you with us?
Yes, I am.
Don't know whether. The question is, how can ADR assist in resolving the non-performing loan problems that we've been seeing in the financial sector?
Okay, thank you very much, Leila. So the reality of the situation is that as a result of the current COVID situation, one of the biggest issues that banks will have to contend with is the NPL, the non-performing loans, which has become quite significant. Now, already, you will notice that the traditional ways of getting these loans paid, which is through the courts or sometimes calling in auctioneers and so on, are not the most suitable. I have a neighbor where I live, where the bank has been trying to sell a house for the last 5 years. So the reality of the situation is that a majority of the people might not necessarily be refusing to pay the money that is owing and that is part of the NPL, but it might be that they have genuine difficulties in paying. And it's in those situations that ADR comes in, so that through methods such as negotiations, through methods such as mediation in certain circumstances, banks can be able to get people to agree to pay some of the money that is outstanding, especially those who are incapacitated because of the circumstances they find themselves in. This might result, for example, in restructuring the facilities, because you will realize that if, for example, the company that is not able to pay are in the transport sector, the bank is not in the business of undertaking transport. And so it is much better for them to negotiate with the person undertaking the business so that he can be able to carry out, they can restructure the facility and they can be able to carry out that business and be able to pay back the bank. So the traditional methods of resolving non-payment would not be very appropriate at the moment. And it may be necessary for banks to come up with other methods, including the options available under ADR, to get some of these payments in. Already, and I think also it will involve lawyers transforming themselves from the traditional methods of saying, you know, we'll send a demand and we'll go to court and we'll get you an order, into people who can be able to negotiate or to undertake negotiations, resulting in a suitable solution for the banks. I keep telling people that methods such as restructuring, where the bank is able to give time for people to pay back the money, is an ADR method itself, even if it is not undertaken with a third-party involvement, but it's an ADR itself. So I think that both the banks and the resolvers, which is the lawyers especially, need to evolve and to recognize and appreciate that ADR might be the only way through which the non-performing loans, which are significant, will be paid. And that taking into account that most of the cases that will be filed, there is a possibility that you'll find defenses such as force majeure, COVID issues coming up, and those might result in either the court ending up having to give time for the payments to be made later anyway, or might delay the collection of some of this money, which can be unlocked through more appropriate methods such as the ADR, where everybody is a winner and nobody feels that a resolution or a solution has been imposed on them.
Thank you for that comment. Deborah would like to just chip in.
Thank you, Mr. Karuri, for that comment. I'd just like to let the House know that we are actually applying those alternative dispute resolution mechanisms. In fact, that is the reason why you'll find people like my learned senior, Mr. Ohaga, wondering why I'm not sending him instructions anymore. Because previously everything that I had in terms of dispute would go to him to resolve in court. But more and more, our in-house counsel in banks are now trained to negotiate those transactions, to restructure exactly what Mr. Karuri is saying. And we're looking at things very differently. I mean, like we all say now, the common slogan is that COVID has taught us that life has to change and we have to be different. So we are doing that. And we have realized that this is actually very successful. Our success rate is much higher and our costs have significantly reduced.
Are we saying you're getting rid of external counsels?
I would say that out loud.
May I chip in also? We used to have arbitration clauses within contracts. We used to have, with the permission of Chair, may I chip in? Yeah, we used to have arbitration clauses in contracts, but increasingly what I do see and other practitioners see are what is called conflict management clauses. And it's a staircase clause where you say if there is a dispute, it shall be negotiated in good faith within this time frame through mediation, through negotiation. And then if that fails, then it spills down to mediation, adjudication, and then arbitration. Arbitration, which is a very coercive mechanism, is usually the last one. So within the contracts themselves, you will find that principle that is has been expounded by Kamau Karuri is there. It's already contractually known that you shall not go to arbitration immediately or to litigation. Thank you.
Kenneth?
Thank you, Leila. From the perspective of specifically on performing loans, in the industry, you have two categories you have the secured lending. Increasingly, we are seeing secured loans becoming non-performing. That's the retail loans, the Visa, the orders, and the cards, and so on and so forth. Those, in my view, are ideal candidates for ADR. You need not go into litigation. The secured lending, you need to now break down the security, whether the loan is hardcore, because hardcore, though, really, it's simply not liquidating the asset. So there's a lot of scope for arbitration and also mediation. Banks are currently talking a lot of restructuring, but it needs within a certain frame. You're restructuring as a mediator, you're restructuring as an arbitrator, so that then it's very clear which method you're using, so that then you add value to both parties. One of the biggest advantages if ADR was used for the non-performing loans, it maintained the relationship between the bank and its client. Currently, if you apply the litigal system for a non-performing loan, more often than not, the bank's lost that client. If you employ ADR, you can resolve that dispute and still keep the client in your books. And that's very important for the long-term profitability of the banks.
Thank you, Kenneth. Maybe while you still have the mic, you weigh on the issue. I know we touched briefly on it in the morning, on the issue of self-representation in such disputes.
Yes, self-representation would be relevant in the financial services sector, because more often than not, the disputes, in this case, of course, we are saying these are non-criminal matters. These are civil disputes. Banks are very good at documentation and procedures and processes. And those are ideal cases for self-representation because the bank is the expert on that dispute. In that instance, the bank may not have to hire external counsel to present the bank in that particular issue. You can have in-house counsel. You can have bank employees who are experts. If it's a foreign exchange dispute, you have somebody from foreign exchange. If it's a trade, if it is a mortgage, if it is a process in any event, you have banks are dealing the broad spectrum, so they can have experts in that particular dispute. This is not to take away from Deborah and her and her colleagues. No, there'll always be room for lawyers because ADR is a legal process. It's part of the justice system. All we're saying is that should you have a dispute in the financial service sector, even in the stock exchange, investment banking, it's easy to bring on board experts, and then you have self-arbitration where the bank then represents itself, because like I mentioned, they're very good in documentation and procedures. So you can even have this only a dispute, which again shortens the time. So self-representation would be ideal for financial sector disputes.
Thank you for that, Kenneth. And maybe another question. Financial transactions are very time sensitive, you know, anything to do with money is time sensitive. Maybe you could weigh on the issue of emergency arbitrator. And if you have that clause on emergency arbitrator in the agreement, does this bar someone from going to the courts?
Thank you for that question. Yes, express procedures, however you know them, whether it's express, there are various namings, but it's an express process, again, will be advantageous for financial sector disputes and specifically for the banking industry, because you're talking of money. This more often than not prevents money flowing from party A to party B. Funds are locked somewhere. And those funds need to be released as soon as possible, but then you don't accrue losses. So yes, expedited processes would be very useful for, again, the documented disputes, where it's a straightforward issue. When it's more complex, involving securities and liquidation, then that can take a bit longer. In terms of, what was the second part? Sorry.
Whether that bars.
Yes, whether it bars. Yes, it would bar because by the time you come to arbitration, both parties have actually decided that their dispute will be done outside the court process. So that locks you into the arbitration. So once you have a contract that has expressed arbitration or mediation, then automatically you're locking yourself out of the court process because both parties have agreed to use this process. So again, it's important for now the bank customers to understand if banks put an arbitration clause in any engagement, what does that mean to me as a client going forward? Thank you.
Thank you. Dr. Kariuki, I think this question is for you. Financial transactions may involve a number of agreements, a number of parties, a number of transactions. Maybe you could weigh in on the issue of joint of parties and joint of issues in such transactions and arbitrations.
Generally, in arbitration and most of the jurisdictions, you would not have joinder of parties without the consent of the other parties. That is certainly the case in Kenya. That is certainly the case in the UK. But if you do know, and banks do know that there are usually a lot of parties involved, that there are going to be many parties, then you seek to rely on rules of an institution that allows joinder of parties. And a lot of institutional rules do allow joinder of parties. So if you are dealing with contractors, you know there are engineers there. You also know there are subcontractors and a myriad other people. So you could go for the arbitration clause that allows you to join the other parties. So that you are thinking backwards, what does the arbitration clause say? What do you want it to say? Unfortunately, not much thought is given to arbitration clauses. In fact, they are written at midnight. They are midnight clauses. So you find you did not think about it that way. The option has always been you go to court. There are issues of privity of contract. The court is able to order joinder. There could also be proceedings in court. But the fear here is if you have 5 arbitrations over the same matter, the 5 arbitrators might not see it the same way. But it's a question of planning. What is it you want to build into your arbitration clause? And I think we'll be discussing that later when we come to the details of the arbitration clause, if we do.
Can I just make a short comment on this, Leila?
Please go ahead.
Yeah, so what Dr. Kariuki says is absolutely correct. We have had situations where we've tried to go to court to get the court to order consolidation of the various arbitrations relating to construction. And that has been a very big problem. One of the cases we did recently is one division where there were claims, there were 3 separate agreements, one involving the contractor, one involving the architect, and one involving the engineer. And so obviously, because of privity and party autonomy, it was necessary that we then commence 3 separate arbitrations. And we went to the judge and said, we would want all these arbitrations dealt with by one person, because you can imagine a situation where one arbitrator says the contractor was entirely to blame 100%. Then you go to another arbitrator who says that in his view, it is the architect, and so on and so on. But the judge said that in her view, because of the party autonomy requirement and the decision and the need to make sure that I'm not forced into a dispute with somebody I never envisaged in the first place, the court refused to allow consolidation. So the requirement for institutional rules that allow consolidation and the manner in which that will be done. And I see the Chartered Institute of Arbitrators has done a good job of coming up with rules on this issue of consolidation, and so has the Nairobi Center for International Arbitration. Now, those give sufficient basis for saying that in situations where the arbitration arises from the same transaction involving the same parties, and where there is a risk of contradictory decisions being made in respect of the same issue, it's necessary for them to be consolidated. So I entirely agree that using institutional rules is important, and that the bankers can now feel more confident that with this kind of institutional rules, it will be possible for multi-party disputes to be resolved through one arbitration.
Thank you. for that additional comments. Just to remind our attendees, if you have any questions, just like in the morning, please log on to menti.com. Just post your questions there. Even the ones who are present there, I've been told because of COVID, even you can't raise your hands. So yes, menti.com and ask your questions. Kenneth, my next question is to you. Are there any initiatives within the arbitration sector that are there to promote arbitration in the finance sector?
Thank you, Leila. Yes, there are initiatives because arbitration is now growing within the financial services sector. One of them is like today's meeting, where we have bank representatives and both in the audience and the panel. So ICC Kenya is also playing its part for the international arbitration, especially for the international banks and the local banks who have subsidiaries outside the country. We also have the Chartered Institute of Arbitrators. So I see there's a great scope. We have the NCIA, Nairobi Center for International Arbitration. So those are bodies that I think can, so to use the word, partner with the sector body, which is the Kenya Bankers Association. And I believe if all these bodies get together, then there's lots of scope for having matters coming into arbitration.
Thank you. Dr. Muga, any additional comments on that?
As I said earlier, there are not only the initiatives, but the way the world is changing to incorporate arbitration as a bridge across jurisdictions. For example, you will find organizations like COMESA have arbitration rules. The East African Court of Justice has just embraced arbitration. So arbitration is being recognized as that instrument that you're going to use to sort out the kind of disputes, unique disputes that occur in the banking industry, which are global disputes. They are financial contracts, and there's no other way we're going to deal with it. For example, now with the UK breaking away from Europe itself, you will find that you may need arbitration so that you are taken out of the national jurisdiction of those courts. So there are initiatives, and there are many. The banks themselves are telling themselves this is the way to go. We are able to sort out the seat of the arbitration, the applicable law, who is going to sit in the arbitration, rope in experts, because this area is very technical. And we do know judges may not know much about this area, at least not in other jurisdictions. So it is, those initiatives are many. They are not necessarily coordinated, but they are there, and they're informed by the reality on the ground, that you need people who can deal with the many things banks do, loan agreements, international trade, project finance. You need experts there. And you also need an award that can be enforced without necessarily having to go to a national court. So you find then the role of ICSID is there, is enhanced in a sense. And the role of those institutions, arbitral institutions, is also enhanced because of the nature of what the banks do and what they deal with that the courts are not able to do. Thank you.
Thank you, Dr. Mwigwa. We're really pressed for time. And as we wrap up, maybe we'll start with you. What is the future of arbitration in the financial sector? Maybe in a second, 30 seconds?
Well, the future is bright, but we need to stick to the conflict management mechanisms without focusing too much on arbitration. Remember, arbitration is coercive. A decision is made, and there's probably no appeal. So the conflict management mechanisms or clauses should be carefully written into all the contracts by the banks. And the future is bright. The future is bright, and this is the way to go. But there has to be very careful thought that goes into the arbitral clause itself. What is it that you want to do? There has to be a very clear understanding by the lawyers of the financial services that we are talking about in a particular context, and where do we want to go? How do we want to resolve that as quickly as possible? Thank you.
Thank you, Dr. Mwigwa. Mr. Karori, do you see the future bright or it's a bit dim?
I think there is obviously the alternative dispute resolution and arbitration are the way to go, but I think that there will also be need to sensitize the consumers on the benefits of arbitration, because the financial institutions themselves might very well want to go this route, but they must carry with them the consumer. So I think once they see the benefit of arbitration and other methods of dispute resolution, I think the uptake of arbitration will be more, and the resistance towards arbitration will keep reducing as people continue to see the benefit. Like the example I gave, where people are willing to renegotiate loans and to restructure them. So when consumers start seeing the benefits of those as compared to going to court, where you will spend 2 years, you might buy 2 years, but eventually the loan is still there and you still have to come and pay it. And also, as Kenneth Militi rightly says, the benefit of having enforceability of the awards that are made across the globe as opposed to just the national courts, I think is something that will make this a better and attractive method of resolving disputes. So I see that future being brighter as we go along.
Thank you very much. Deborah?
Thank you, Leila. I wouldn't say it is bright, but I'm sure you will know what I think about arbitration after I make my remarks. From a user perspective, while we embraced arbitration, what we have found as banks is that we have ended up where we were with litigation. And this is because we have made the process, as I'm talking to the practitioners, arbitration practitioners. So it is long, it is still complex, and it is very expensive. So when we compare the two processes, we really are at a point where we are asking ourselves, is this actually what it was put out to be? So I think the practitioners of arbitration have strangled arbitration. It had good intentions, but what has happened is we have strangled it because we've made it so complex. And unfortunately, I'm going to hit on my colleagues in the profession, the lawyers. We are very complicated, so we have gone in with the same mentality that we had in court. That is what has happened. So we as financial institutions are it with a keener eye of whether it is actually giving us the benefit. And we're actually embracing other methods. For instance, mediation. I am a great supporter of the court annexed mediation. I was sharing with my colleague, Ms. Kendagor, that I have had a successful case, which was concluded in 6 months. So that's, whether there's the future for arbitration is bright or not, I leave that to you. But those are our sentiments in the financial sector.
Thank you very much, Deborah. And I see you are directly looking at my boss, who, has spearheaded a lot of initiatives in this world. And I'm sure he's taken some notes of that, Kenneth?
Very interesting question you've asked. Both as a bank and arbitrator, I've listened to what Deborah said very keenly. I've picked that up. The potential, again, depends on the role that is played by the various institutions. What I can say is there is great untapped potential. If you look at the volume of cases in litigation compared to the volume of cases in the alternatives, definitely there is great scope to move from litigation to arbitration. But again, it depends, and the solution for the banks is to incorporate ADR policies. One, you have policy-driven decisions, because then from policy, you drive then into the strategy. So for the banks is to have a deliberate arbitration policy or a mediation and ADR policy, so that then it will take care of lots of the challenges that Deborah and the other banking industry practitioners will talk about. Because the benefits of arbitration are there, but they need not be there in theory. They need to be there practically. For example, let me give you a practical example, is to have expedited clauses in your arbitration agreements, where it clearly stipulated, and we saw in the earlier panel where Ngotho spoke about, you have 21 days clear timelines, 7 days for every step of the way. Then you close the window from any lengthy processes. So again, that is also policy driven. And I can assure you, Deborah, that from this, I wish the chairman of CIAB was here. The way I see is collaboration between the various arbitral institutions and the umbrella body, which is the Kenya Bankers Association. Then the future is bright.
Thank you, Kenneth. The Chief Whip Mercy is telling me we only have time for one question. Any question? More corporate forensic investigation roles are seeking arbitrators. What is the role of ADR in financial crime, which is a criminal offense? Thank you, Mercy, for your generosity.
Okay, I'll take that because then, as you know, criminal issues are not arbitrable. So I think that will, at least in Kenya. So the role of ADR in financial crime, I would say, is practically extremely limited. When you talk about forensic investigation roles seeking arbitrators, perhaps then you're talking about the experts that we spoke earlier. Then you can have the experts coming in to help with the forensic investigation. But overall, for that question, the answer where an arbitrator can make a decision, I wouldn't see much happening there.
Thank you, Kenneth. The second question? Dr. Kariuki mentioned some matters are not arbitrable. Is it possible to have arbitration clause in employment contract? Dr. Kariuki?
Arbitrability, and I wish we had more time, but we don't have, is a question of national law. The national law will tell you in this particular jurisdiction, this is arbitrable, this is not arbitrable. And in the Kenyan context, there's a debate as to whether arbitrability is expanding or reducing, seeing as it is that actually even some criminal matters can be subject to ADR. So are we expanding, are we reducing? But generally, the rule of the thumb is that criminal matters will not be arbitrable. Can you have an arbitration clause in an employment contract? Yes, you can. You see, remember, this is contractual and it's two parties agreeing. And if you do agree and put it down on paper, it can be enforced. Thank you.
Yes, maybe I can support the answer that Dr. Kariuki has given, since now we are under the scope of ICC. Yes, employment contracts, you can have an arbitration or even mediation clause. It happens a lot in other countries. In Canada, it's there. In the US, it's there. In Australia, it's there. So for us in Kenya, again, is to incorporate that into the policy. And then the strategy will follow from there.
Thank you, Kenneth, for those additional comments. I think that's all the time we had. Mine is just to thank my lovely panelists and the attendees.